I'll go first or second. Okay. Well, good morning. I think it's still morning. I didn't check my clock, but a couple things I wanted to say that we heard in the court case that I just wanted to remind people of. The 5 issues that the governor brought up that he wanted to renegotiate. I want to say that we all agreed upon those issues when we were negotiating. Myself, the speaker, and the governor. That doesn't mean we all thought that they were the things that we should do, but in the end, when we compromised, those were the things that we all accepted. I will tell you that on the Republican side, that we spent more money than we wanted to spend. That was part of our agreement. We didn't spend the money that we wanted on pre-K. We wanted that to go on the formula, but we accepted what the governor wanted there as well. We modified the buffer language. We wanted that more modified, but in the end, we delayed the enforcement. Those are things that the governor wanted that we didn't want. And so I just wanted to remind people that was part of what we did. But today in the hearings, my hope is that the courts rule in our favor, obviously. If they do, it's status quo. The governor still has all the power that he had. If they did rule in the governor's favor, he suddenly has more power than he's ever had before. And so it was very, very interesting on my part sitting in there and listening to them. And I don't know how they're going to rule, but obviously I hope that they rule in our favor.
And I would just say that I'm disappointed that the governor continues to fight this. This is a clear violation of the separation of powers. I thought it's a pretty clear-cut case, and I'm looking forward to an outcome that looks just like the outcome in the district court. We had negotiated these bills in good faith. Our attorney laid out our case very well, and I'm hopeful of a very positive outcome.
Madam Leader, a lot of people are asking in there, how can you be negotiating in good faith if you put a poison pill in the bills to force the governor to sign it, coerce, control, and constrain him, as they said in there?
Well, I disagree that there was a poison pill. The governor saw that bill, his staff. He has many, hundreds of people on staff that saw that bill. It was posted about 39 hours beforehand. And I would also just point out that if the governor was planning on signing the tax bill, as he had indicated that he was planning on doing, that wouldn't have been an issue anyway. So I think that he should, with his resources of hundreds of staff, be able to see that was in there. It was in several versions, and if he had an issue with that, he could have pointed out to it, or his staff could have pointed out that to us before.
He should have seen it?
Well, it was in the bill for at least 39 hours. So for him to say that there wasn't any indication from him at the time that we should take that out. Why was the language in the bill? Well, I mean, I think you can look at what had happened the year before about when he had told us that he did not intend to hold the tax bill hostage, and then he ended up vetoing it. He had indicated he was planning on signing the tax bill, and after we put the language in, it was very clear that he intended not to sign the tax bill, despite the fact that was the information that he had given us.
How concerned are either of you that 4 of the just 6 justices presiding in this case are Dayton appointees, and several of them ask some pretty skeptical questions of your attorneys?
Well, it's their job to ask tough questions, and their job is to be nonpartisan, non-political. They're hopefully looking at all the case law, looking at the Constitution, and if they do that, I'm confident they'll come up with the right decision.
Yeah, the questions I thought were probing on both sides of the issue. It's my hope in the end that they do the job that they're supposed to be and rule fairly, and so I'm not worried about it.
He just has a personal commitment that he's at. It's my understanding. Well, I could have live streamed it, but I had an opportunity to come and see.
Were you just personally curious?
Well, I mean, I think this is very important on behalf of, obviously, the House and the Senate, and this is a huge potential for precedent. So if the court were to agree with the governor, that would be a huge precedent-changing event. So I think it's a very important time in our history.
What about the live stream? Do you support more cameras in the courtroom, and are you pleased to see this development so that Minnesotans across the world can watch it?
I got a text that the camera was on me and that I should pay attention. So no, I think it's good. Yeah, but I wanted to talk about why I wanted to be here. I mean, this is historic. If the courts did rule in the governor's favor, that could potentially ripple across the whole country, moving more power to the governor's branch and executive branch. And so I wanted to witness this. And I thought the testimony was good on both sides, but I think the common sense, I hope, will lean in our favor.
Can you talk a little bit more about cameras in the courtroom, whether you'd like to see this trickle down?
I'm okay with cameras in the courtroom. I mean, I think especially in a case like this where the people of Minnesota, I'm sure, are curious and they have a right to see what's going on. So I'm okay with it.
The other side argues today if they were to lose and you were to win, this would tip the balance of power in favor of the legislature permanently. What do you have to say to that?
I disagree completely. If the governor were to win on this, it would, as the Judge Guthman had said, it would literally abolish the legislature. You're taking away a branch of government, and so it would give the governor much more authority, or as the judges argued, potentially the judiciary much more authority than the legislative branch. So I think just the opposite.
But the issue they brought up there was that the line item veto is disqualified from taking out the legislative. Fundamental legislature is absolutely over its own point of view. Do you agree or disagree with that?
No, I think our lawyer made a good point on that in the case in Montana, where the legislature tried to give themselves a big increase, and then that's a whole different discussion. A veto of the whole, the general veto, where the legislature has to go back into negotiations with the governor to come up with the solution. Here it would just be there's no way for the legislature to come back. The governor has to call us back into special session.
Yeah, and some of the testimony they talked about, the House had about 4 months of resources to continue, but the Senate really only had about a month, and so we would not have been able to function. A number of our chairs have been holding committees on a number of issues in the interim. We wouldn't have been able to do that. And then who do we decide that we're not going to pay? It really would have been effectively would have abolished us.
And I don't think, and I think the 4 months was too long. I think it's something more like 2 months. I don't have to get back on that number, but it wasn't 4 months of funding.
One more. Go ahead.
Their ruling would be that this would only be likely, it would only rule in favor of the governor if indeed it was narrow and it was a poison pill situation. What do you think of that?
I'm not sure I quite follow your question.
They can only do a line item veto when you put a poison pill in, is what the other side is suggesting. What do you think of that?
Well, for us, it goes back to a separation of powers issue. We just don't think that he can do it. The poison pill, quote poison pill, it was something he saw about 39 hours ahead of time, or at least his staff did. And in the end, that was how we did it to get him to pass the tax bill. That was the part that the Republicans wanted. We wanted tax relief for farmers and for seniors and for students and a whole bunch of other people. That was the part that we were fighting for, and if he was going to veto that and got all the spending and all the other provisions he wanted, we didn't think that was fair. So,
about adjourning sine die rather than letting this play out a little further, knowing that this might have happened?
in the House and Senate, we usually adjourn sine die, and that was, I think, part of what we, in good faith, we say we're done. Sometimes governors don't know what we're going to do after that, and they like it normally when we adjourn sine die, so that was nothing but how we normally do business. But with that, we're going to wrap it up. Thank you.
Thank you so much. In court, the justices were arguing you could have vetoed the entire tax bill or the entire appropriations bill, and you would not have been here.
See, to me, this case comes down to you're going to read clear and simple the language of the Constitution, which gives me the line item veto authority, and which says that the separation of powers applies except in the instance expressly provided in this Constitution, which Article 4, Section 23 does, with the line item veto. The rest of the hypotheticals and what ifs and what are the consequences of this, in my judgment, are separate considerations. The core question here, which the Supreme Court, I hope, will answer is my veto constitutional? And I believe it clearly is. Thank you.